That's why it's a race of disclosure, and the side which gets their points over the most vigorously and the fastest is the side that is ahead. And when you're given the first opportunity in your voir dire is really first. You can educate your jury. That's what we did in the old days. We did too much educating, and it took too much time, and as a result, we've lost a lot of the right to voir dire, and the judge has taken it over, but we still have, in most of the court, the right to do some voir dire. I think it's absolutely essential. Next, you have the opening statement. The opening statement is very important. Ben Hallinan once said a long time ago, in answer to the question, what's a good opening statement? He says, a good opening statement is one that makes the jurors want to go out and vote for the fellow who made the good opening statement without waiting to hear for the evidence. They're convinced already.
Central to a case is the case theme, or sobriquet, an attorney can develop to give the jury a handle on the chain of argument.
In a trial, I think that you sometimes have to relate your case to one specific instance rather than 5, 1, 2, or 3 at the most, and hit that on voir dire. I remember my air embolus case. You ask the jury if they're familiar with the capital punishment laws of some states, and voir dire, and it'll be ruled out of order because this is a civil case. You mention something about capital punishment in the opening statement, and then you explain about capital punishment during the course of the trial. What you're trying to do in that air embolus case that I commented on is to show that it's almost in the public domain that an air embolus into the bloodstream will cause death, and indeed capital punishment in some state is induced by putting an air embolus, and then the argument that this is a very rare thing and no one knows anything about it, even medicine, is not so, because everybody should know that an air embolus will cause death if it in some states is used for capital punishment. So you refer to a case, you give a sobriquet to a case, you give a name to a case. The case, if you read modern trials, the case of the shaking house, the case of the iron handshake, tells of a lot of cases where there was something in the case that focused around shaking the man's hand, and after it had been broken, he can't shake hands again, he can't have a normal hand. Or the case of the house and the earthquake. There's something that stands out in every case. You go to a movie. When you come out of the movie, they say, how'd you like that movie? You tell them if you liked it, you tell them if you didn't like it, and then you tell them about one episode in the movie. One thing stands out, The Godfather. The thing that stands out to me in The Godfather was when one of the characters went into the bar, and the bartender had an ice pick, and he was talking to the fellow that went into the bar, and he took the ice pick and drove it right into his hand. And when I said I liked The Godfather so much, it was so great to see it, I told him about that one thing that stood out in my mind. That capsulized the brutality, that capsulized the characterization of the movie, the cruelty and the vividness and all the rest of it. Same way with the trial. One thing stands out, the case of capital punishment. It was a medical malpractice case where they put an air embolus into the bloodstream, but I called it the case of capital punishment, to dispute the fact that this was something that was a rarity that no one knew anything about. Any damn fool doctor should know you put an air bubble into the bloodstream and you're not careful, you're going to cause a heart dysfunction.
The sobriquet, or theme, is introduced in the opening statement and expanded upon and reinforced all the way through the trial to the closing.
I remember one in Chicago that the railroad accident was caused by 2 trains that collided. Of course, it was 2 trains that collided. They were both on the same track going in different directions. And I remember that the judge had commented to the jury in that. And the first time the comment was like this was made, and they held that it wasn't a mistrial, the judge said, it was a hell of a way to run the railroad, trains going in different directions on the same track. You can pick out of your case, like the ice pick in the hand. You can pick out something in your case And you don't have to be a genius to do this. There's always one thing that stands out in the case. The wrecking wheel with the fire engine, the case of the aerial photo, the X-rays, the case of the enlarged X-ray, case where you've got Ordinance 107. Ordinance 107, not to walk on the streetcar tracks, except, there's an except in there. And no one knows what Ordinance 107 is, but yet, when I voir dire the jury, I ask them, ladies and gentlemen, do you know what Municipal Code Ordinance 107 is? Of course they don't, but they've heard Ordinance 107. Maybe they'll look at each other, but they probably won't until you talk about Ordinance 107 in the opening statement. Then during the trial, you read 107, and then during the final argument, you explain 107 that says you can't be on the track except in certain conditions. And you build your case around that 107. You build up suspense. What is 107? And then you show that 107 is the guts of the case. It's the thing that makes it right or wrong. And it's the important part of the lawsuit. And then when you talk about that case later on, you talk about Ordinance 107. Or when you got the case of the little girl that was deseparated because they gave her dope at the St. Francis Hotel. You talk about the minor and the St. Francis Hotel. The minor and the St. Francis Hotel. It connotes a lot of things. So individualize your case as to one thing. Think of The Godfather, that one thing that stands out. In every case, if you don't individualize your case, if you don't have something that stands out, you haven't given personality to the case. You haven't made it stand out. You haven't dramatized that sufficiently to the jury so that it justifies their attention, their memory. Oh, I remember that case, the case of the minor at the St. Francis Hotel. So one thing that stands out in every case.
Picking the right case theme can be especially helpful in offsetting preconceived notions or bad publicity a client may have gotten in the media.
I remember one time when we had the black-gloved rapist, so-called, in San Francisco. He raped a number of women. He wore black-gloved. And when the case came to trial, all the paper referred to him as the black-gloved rapist. Well, they had tarred him so that he wasn't going to get a fair trial. So I tried to give it a theme. I was able to prove later on in my opening statement, they call him the black-gloved rapist. He's not. He's the errant choir boy. And I built on that, and I showed that he had gone to church at least once in his lifetime, but I didn't overdo it. But I showed that he did have a priest. His mother was God-fearing, and he sang in the choir once. So I had as much right to call him the errant choir boy as they had the right to call him the black-gloved rapist. Again, this I think, emphasizes that there is no man so bad but what he doesn't have some good in him, and a good lawyer will find out that goodness. If you go to a good lawyer and you're guilty, he's got to work hard to find the good parts. If you're innocent, the lawyer doesn't have to work so hard. But be sure that you pick the theme that tells the story and tells your side. That if you were on the defense side, you wouldn't say the minor in the St. Francis Hotel. You'd then take the best side of your case and say the girl who claims she was a minor in the St. Francis Hotel. You tell the other side of the thing. Case is never so bad that you can't find something on the other side. And that brings me to one of the most important things, I think, in the law. Do I represent guilty people? I sure as hell do. Because I don't know that they're guilty until the jury says that they're guilty. Guilt is a mixed question of fact and law. It's what the community wants to do. Maybe the community doesn't want to send this guy away or this kid away or this woman away. Maybe they feel that the unwritten law, and there is such a thing as an unwritten law, you can't instruct on it, But the unwritten law is the emotion. It's what you want to do. It's a prayer that you may say when you go to bed at night. If you're sitting on the jury, God help me, God guide me on this case. What your inner consciousness says that you're going to do, because when you sit on a jury, your best motives, your inner consciousness, the thing that makes us a nation, that sets us apart from other countries, our jury. We have our rights and wrongs decided by our neighbors, who are us.
Dr. Belli explains the advantage of considering summation arguments in advance of constructing an opening or a case theme.
Why did you take the case? What appealed to you? The main thing that appealed to you, and the main thing that you knew was against you. You've got to put that down on that page in your book when it comes to opening statement and argument. You've got to explain that to the jury. Don't say, this is the reason I took the case. You have to explain, the thing that appeals to me is, and so forth, and you explain the logic and why, and you explain why you feel that this is important to show that the client is innocent or didn't do the particular thing that they were charged with doing.
Many times a case theme or argument can be strengthened through the use of common parables or analogies that are well known to jurors before they set foot in a courtroom.
You know, parables, analogies are probably the most potent thing in argument. I'm not a great student of the Bible, but in the old days, in final argument, it was like a biblical class. Lawyers on both sides used the Bible, which to me proves that the Bible says almost anything if you look hard enough for it. Maybe you can find anything in the Bible depending on what you're looking for. I've many times used the fallen woman of the Bible, of which there were many of them, saying to the jury that we must protect her. We must be the ones that give her succor, give her relief, as the good Lord will in the Bible. You'll find almost a parable or analogy to almost any situation in the Bible, and the jurors still like it. We don't use them as long, as lengthy, and as floridly as we used to in the past. But if you find a good appoint, or go to your minister, find someone to give you a good appoint, it never hurts to give an allusion to the Bible or something that happened to one of the characters in the Bible. Gives you not distinction, but it gives you a little, shows you're on the right side. I would use it if you can.
Analogies are particularly effective when used to compare aspects of your case with known people, places, or events.
Analogies, yes, you can use analogies to acts of state. You use analogies to war crimes trials. The magnitude of someone's sin compared to another. It's always more effective dealing with something sidebar, having it reflecting on your case and going directly to your client, because they've heard everything about your client. Refer them to something collateral. See how that was treated.
There's also a golden rule of educating a jury a lawyer best not break.
You can't say to a jury, how would you feel if you had that broken leg? You wouldn't take $5 million for a broken leg. Well, and that's a golden rule, and if you violate the golden rule and say, how would you feel or how would you like this, it's cause for mistrial. And how do you do? Well, then you do it a little collaterally. Ladies and gentlemen of the jury, let's go down to the waterfront. And let's get Joe Simon. Joe Simon is a big, overweight black man. All he does is live. He spends all his money. He's a bum. He likes being a bum. He's lost his leg. You've got to compensate for him losing his leg. And as the federal judge said in Maxey versus Southern Pacific, all man does is live. You're not bums. You have jobs, you have families, you have homes. But all man does is live, and the man down on the waterfront enjoys being a bum. He has a right to be a bum, a constitutional right to being a bum. He likes to smell the flowers. He likes to smell the sea breeze. He likes to hear the foghorn. He likes to sit drinking the wine. That's his life. He has a right to do that because all man does is live. What would that man take for the loss of a leg, even though he didn't work or he couldn't work all the time? He's lost a leg and he can't work. There's pleasure in working for him. What would he take? Would he take $5 million for the loss of that leg? $1 million for the loss of that leg? You have to relate it to the man who's a living person and all he does is live.
From opening through closing, it's imperative that a lawyer maintain a proper attitude towards a judge.
Be sure, number one, that you're prepared, that you've researched all of the law, that you don't cite any law that's been overruled or get yourself in trouble by telling the judge something that isn't the law. I think being candid is a great help in handling so-called a judge. I think that above everything else, don't blow your lid no matter what happens. Protect your record, of course. Take exceptions, but you can take exceptions. And you can do an objection politely and legally. A judge, you have to give him every benefit of the doubt more than he has to give you every benefit of the doubt. He may know you, may have heard things about you, or if you're in a strange city, he may have heard things that aren't too good about you. And he may be kind of testy. You can change that if you're gracious, if you're as hospitable as he should have been, you being a stranger to that city. And you can get him almost saying to himself, when you close that first day of trial, this guy isn't such a bad guy, and number one, he's prepared, and number two, he shows respect for the court. You can win more people over by trying and preparing and being yourself and a good personality than you can by criticism or you can by being curt and looking for ways to criticize. There's a lot of ways to criticize. There are more ways to applaud and more ways to congratulate a judge and people than criticism. It's your job as a good lawyer to find them. And don't be insincere, don't be a sycophant. But on the other hand, the judge is a judge. You're a lawyer. The judge and the jury above everyone else is expecting the lawyer to show more respect to the judge. If the judge takes you on, the jury is going to resent that of the judge and they'll be on your side.
Besides maintaining proper decorum, there are other things a lawyer should do and should never do during a proceeding.
Well, the one thing that a lawyer should never do if he's for the plaintiff is to lose the case. If he's for the defendant in the criminal case, is to have his client sent to jail. It may be facetious, but that's number one. If you're trying the case, you're trying it to win, or you're trying it to make a record so that you'll reverse it upstairs on appeal. Don't talk down to a jury. Never talk down to a jury. We are going to decide this together. I remember the great Spot Mazingo, who was Speaker of the House in Darlington, North Carolina. He'd been out on one the night before, as he was wont to do, but it didn't hurt him when he got up in front of the jury. He stood in front of the jury, and they could see that he had been out the night before, and he said, "Ladies and gentlemen, the jury says it's going to be a rough day for me." He said, "I didn't have a chance to do much on this case as I usually do," and the jury could see why, and they all knew Spot because he's such a great character. He was such a great character down there. He said, "Ladies and gentlemen, I tell you what we're going to do. We're going to learn about this case together. You and I are going to find out about this case together, and you'll excuse me if I go over some things more than I usually do, but I've got to learn, and you've got to learn. I know that you're fast learners, so I'll do it as fast as we can, and we'll start in right now. Now, in our learning process, I'm going to make an opening statement. I'm going to tell you all of the things about the case that I know, and we'll learn more together as we go on through the lawsuit. Now, When you do something like that, you take the jury into the trial with you, and they follow along with you, and they watch through the trial as to what the teacher said, the lawyer, what he thinks, what he's trying to tell us. I think that was a great story of Mozingo telling the jury that we're going to learn about this together. That makes them all think right away, yes, we're going to learn about it together. That's what you're trying to do to a jury in an opening statement. When you stand up, you're going to give them the whole case in the opening and tell them all about it. And in the opening, too, you're going to use words like res ipsa loquitur. You're going to say Ordinance 742. You throw it away. Ordinance 742. You're going to voir dire them. Do you know about Ordinance 742? Of course they don't, the municipal code, but they heard the 742. By the time you get to a final argument, they've heard this Ordinance 742. What is that, Evidence 42, 742? Then in the final argument, you're going to have a placard, a big blow-up made of 742. Ladies and gentlemen, you've heard me allude to 742 so many times that you're sick of it. You're not as sick as the plaintiff, and that's the reason I've got to do this on 742 to tell you what the gist, the guts, the gravamen of this case is. And then you show 742, and then they've been forewarned about 742. Finally, they're curious what it means, and this is the whole part of the lawsuit. It magnifies, it aggravates 742, and that's your whole case, and they can see then how important it is, how important you think it is. And you've put all of that time from the very beginning. It must be important if the judge is going to instruct on it, too, and you might even have the judge's instruction. Ladies and gentlemen of the jury, I give you Ordinance 742. If you find in your deliberation that there was a violation of this ordinance, then that of itself is negligence. 742. What they see before them and what the judge instructs them on, they don't forget.
What does a lawyer think when he's up before the jury? How is his mind working? Is it on the case or other things? Dr. Belli's insights may surprise you.
With me, the delightful experience of standing up in front of a jury and reminiscing. I don't get to the two current things because some of those I missed. But the things that Captain Kidd, the wonderful, great human being law professor who taught me criminal law over at Bolt Hall, oh, Lord, that was in the 1930. I recall stories, analogies, things in the law that he told me, and without having prepared it or without having thought about it, they come out. They come tumbling out. Why? Well, because I love the law, and I love what I'm doing, and I love the case that I'm trying, and I generally love my clients. I think when you're standing up in front of a jury, you have a meeting with them, you can tell them immediately. When I go to a strange city and I'm standing up in front of a jury, I see some of them looking me up and down. This is a guy that everybody calls the king of torts. He's flamboyant. He thinks he's the greatest, which I do. It would be malpractice for me trying that case if someone else I knew of was greater. That's my excuse. I don't know if it satisfies you, but it satisfies me. But anyhow, I stand up there in front of the jury, and I have a feeling that I like them. And I think that feeling comes over. And when I'm standing there, I can tell what they're thinking of. And the one thing that they're thinking of is if he's so good, let him show it. And I can see them actually sit back and say, let's watch him perform. Well, that's fine for me. If I am good, then it's up to me to show it. And I accept the challenge, and I do try to show it. And if I do show it, then I'll get more in an award that the local man would, who hasn't been announced as being the greatest. They'll say, well, by golly, he is as good, I hope. He is as good as they say he is, and I think he's telling the truth, and so we'll give him the award that he asked for. Now, I've had that happen many a time, where the jury has come up after and said, we heard a lot about you, and we were talking in the jury room, and they'll say, well, he's going to have to live up to his advance billing if he wants us to go for him. Otherwise, we think him a bag of hot air and so forth. I do get a better reward than the local men sometimes because of the advance billing.
While an attorney can't always count on flukes or luck in a case, he should not underestimate their special value.
Gee, how much of a role does luck play? If you're fortunate enough to try it on a national holiday and you've got an ex-soldier or a veteran, if you try it in the Christmas season. I remember Pat Brown, before he was governor, he was district attorney, he sent it over to me to try for him. And I remember the transcript showed that I'd made some allusion to Christmas time, and the insurance companies took it up on appeal and said that there was a Santa Claus down in front of the courthouse with the Salvation Army pot, and you could hear the bell ringing up into the courtroom. And they said that every time that the bell would ring, Belli would cock his head to the side so the jury would know that they should consider the Christmas season and be benevolent. Play any part? And yes, I think we were just lucky to go to trial at Christmas time. Jury are more notoriously generous. The appellate court took the opposite view. They said that the appellant says that we should discontinue trials during Christmas time. The jurors are more benevolent. We've got to keep the juries open at Christmas time. They dismissed that in about 2 sentences.
In trial, there's also the idea that a good lawyer can make his own luck, as Dr. Belli did in the Reckenbiel case.
I think luck does play a part, but you have to distinguish between luck and something that's planned, such as in the Reckenbiel case. We had in Reckenbiel a fire captain who was riding on the fire truck. He went through an intersection, and a truck came into the intersection and ran into him. We had a siren on, and with the siren on, we had the right of way. The other people should have heard the siren, should not have run into him. So the sole question was the siren on? What I did was sent my investigator out all around the intersection, like you draw circles, close in, farther out, and he got witnesses. He got about 30 witnesses who had heard the siren, at what time, what did it sound like, and so forth. Then we took an aerial photo of that intersection. Here was the intersection right here. Here was this fellow lived 500 feet away. Here's one that lived 100 feet away. Here's one that lived over half a mile away. We showed the great big blown up picture of the intersection, the aerial photo, and we made it like a zone of sound that here, this fellow lived here, this fellow lived here, this fellow lived here, around the intersection there. And then I drew lines around in circles, 50 feet away, 100 feet away, 200 feet away. The truck went through those zones of sound, figuratively. Here again, you have in demonstrative evidence that you're making specific and tangible, that the truck was like going through a zone of sound, ran almost through something that was tangible and it could be seen, certainly it could be heard, and ran into our fire truck. So there was no question there was no question that these people, if they heard the siren 500 feet away, 50 feet away, that the other truck that came down the street and ran into our man in the intersection was violating his right of way. And they found for the plaintiff in that case, a very tragic case, and that was a case that went for the highest verdict in the world at that time. Gianna, what was that, 35 years ago? I remember Bob Callahan was in the fire department. And I was representing the fire department at that time, and he was the one that brought the case to me. I remember when we tried that case, and I was giving my final argument. As I was giving the final argument, the fire truck ran by in front of the city hall, the fire siren wailing. I'd stopped my argument. It was so loud. The jury all looked up. And of course, I looked up and shook my head. I just can't, so much noise. That's unethical? Hell no, that's not unethical. Fire truck just happened to go by there because Callahan had gotten his firemen to do that for their lawyer. I just wanted expressly to show them how much noise a fire siren could make, and that's what happened. The judge shook his head, but he allowed it, and he thought it was all right. But I thought that was one of my best cases, and it was the best award that I had or that any other lawyer had in the English-speaking world up to that time.
Instructions in special issues are most effective when presented in a certain manner.
Instructions are tremendously important in trial, whether you're asking for special issues, special instructions, or your general instruction. I like to have my instructions handed in before voir dire. The first thing that you do when you're making your ad limine motions before trial, you give your instructions. You give him also your trial brief. You give him your law on the instructions. And remember, be sure you have some clean instructions without law or anything on them or without your name or anything on them, because some of those instructions are going to be submitted to a jury. Special issues were the bane of a trial lawyer's existence down in Texas. The greatest offender state in the United States, where too many special issues were asked, it was impossible to sustain a verdict because the general verdict for the plaintiff would be followed by a barrage of shots that were inconsistent, and they would nullify each other. So we don't have the special verdicts like we used to have in Texas. But special issues sometimes are good in instructions, provided you don't get the jury to be inconsistent on them. And you go over them, of course, with the judge beforehand and show why you need a special issue in this case on this particular point and that particular point. But I'm a little concerned with special issues, not to give too many of them. I've seen general verdicts fouled up by using special issues.
Objections is another area where an attorney has to be careful not to overdo it.
How about objections during the trial? Make as few as possible, but if there's an objection to something that you should make for two reasons. One, you don't want the jury to hear the testimony. Two, you want to preserve a record on appeal. Make it. If you make too many objections, then you haven't done your homework, because the objection should have been made ad limine before the trial. Anything that you think is going to be objected to that's privileged or that's prejudicial, that the man has AIDS, and you don't want to have that brought out because it's irrelevant to the trial. You should have brought that up in chambers before the trial started, and you should have had a brief on it, and you should have argued in chambers so that you won't have to argue it and belabor it in front of the jury. If you haven't done it ad limine, then when you get on trial, at least when you see that the other side is getting into forbidden territory before they blurt out something, or before you have to say, I object to that because, I think you should say, may we approach the bench, Your Honor? And if it's a serious objection that's going to take a little time and a little arguing, say, may we approach the bench, and then say, may we go into chambers, Your Honor, and argue that out of the presence of the jury. There are speaking objections that some judges don't allow and don't resent. As a matter of fact, some judges will say when you first come into their courtroom, look, when you make an objection, state the legal grounds and don't make a speaking objection, giving the argument and the grounds for the objection in the presence of the jury. If the judge allows a speaking objection, it's a good time to get in a tiny, little, succinct, terse argument. The jury hears, that the judge gets, even if he overrules your objection, at least you've told the jury why it's unfair. The jury doesn't like something that's unfair. They don't like something that you say is unfair. You've got to show them why it's unfair, why it's illegal, why the other side is trying to put something over, not on you or your client, but on them. That's the important thing. He's trying to put something over on the jury. We're going to determine this case ourselves, ladies and gentlemen. See, we, the lawyer and his plaintiff and the jury, are trying this case to them to get justice.
And what is a closing argument or summation?
But summation is just that. It's not argument. The florid oratory of the past, the quotations from the Bible, the ranting and raving, the storming and sweating about the courtroom, isn't seen as much as it used to be. But still, argument or summation is the time when the doves, figuratively and literally, are released, when the American flag is unfurled and all the rest of that, because it's your time to show your client and show the jury why you've been hired, why you're in there, what you're there about, why you've taken their time. Don't apologize for keeping them so long. Reward them in what you say. Show them that it was worthwhile for them having to go through all of that testimony to hear you now in what you're going to say. In argument, trial is one thing, from voir dire to opening statement, testimony, and argument. You carry the same thing all the way through. Remember the example I gave, you talk about res ipsa loquitur. Will you follow the instruction on res ipsa loquitur? You ask them that on voir dire. You tell them a little about res ipsa loquitur in the opening. Now you're going to tell them fully about res ipsa loquitur. You make the trial a whole thing. You make them remember on back. You summarize rather than argue. But you tell them what the case is all about. To be sure, pointedly, you have parts of the testimony written up so that they can follow the court report and say something like that. I am prejudiced. I know my client. I don't know. You don't say, I know my client. You'd be violating the golden rule. You say, I may be prejudiced, so I can't tell you to do what I would do, but let's take the one unprejudiced person in this courtroom, that's the court reporter. I've had her write up some of the testimony. I want you to listen to what the defendant himself said, and then you read some of the testimony of the defendant, some of the testimony of the other people, or you read some of the testimony in the depositions, or you read some of the exhibits, and not only do you read it, but you have it blown up and put it on an easel and let the jury follow it, and you go through it to show this is what is said. Remember this, and it may be the most important part of the whole case that you point to, and this you can't dispute. So you place these placards around the courtroom and you refer to them. You have the jury look at them, and then you summarize. You say what the evidence is, and remember in the opening statement I said this, that I was going to prove. Now I have proved it, and show how you have proved it. And then in argument, and pull this thing together. Then you talk about His Honor's instructions. You may have some of the instructions that His Honor is going to give you written up, and you show those to the jury and have those on easels around the courtroom and explain what they are. And if you have any questions, ladies and gentlemen, you come back and have the judge read this to you. It is important. It is the law that you will want to follow, and it's a fair law, and it's a just law, and you explain why it is and how it is. It's a great opportunity to explain to the jury why you took that case. Express your feeling. You wouldn't have been in there. You wouldn't have been standing up there. It's your opportunity to show why you're there, why you took that case on, and by golly, you're not stupid or wrong for having taken the case on. You're now proving it to the jury that you were right in taking it on, and they're going to be right in returning a verdict for the plaintiff. Let them feel your sincerity. And whereas you don't do the old Florida oratory that they used to do, let them feel and see your sincerity, and let them see the transcripts actually said, the deposition, the instruction, so that it'd be a missed prison if they didn't vote for you. Final argument, the final part of the lawsuit, the summation, the reason that you're there. That's the most important part of the case, although the whole case is won.
A lawyer may give his best and still not win a case, as Belli did in the Jack Ruby trial, although he later reversed all counts on appeal.
But I remember in that, I really was feeling for Jack and the injustice of this fellow who I felt was mentally incompetent. And I think it leaked through, at least so that the appellate court reversed Jack Ruby's conviction and sentence of death and gave him a new trial, and the poor fellow died before he could be tried again, and I think this time he wouldn't have been executed. He would have been sentenced to a term or been sentenced to the term that he had already served. I think that was one of the best summations that I ever gave, and the Texas jury, for my pains and for poor Jack's pains, found him guilty. But as I say again, we reversed that one. I can remember a number of other ones that I did that I was proud of, and I can remember some that I was proud of and the jury held against me, and I went out behind the courthouse, and with my client, who didn't go up behind the courthouse because he went to jail, I cried and cried for a long time. But the main thing is I did my best on the thing. Sometimes that's not enough. Sometimes not enough. You lie awake at night and think what you should have done, and gee, when you think what you should have done, you resolve never to make those mistakes again. If you do the latter, then I think you can be excused, almost.
Sometimes a key piece of demonstrative evidence is saved for summation because of its dramatic or powerful effect.
You know, if you've got anything unusual, emphatic for a final argument, a piece of tape that you had an audio in court that you can give a few words that the jury can listen to, or if you had a television deposition that you can play a few episodes on that, you bring that back to them. But in lieu of that, the placards, the blown up pages of the deposition, the transcript, the judge's instruction, the statement, the ordinance, whatever you're focusing on, blow that up, put it on an easel, and point to that. Let them see it. Again, the demonstrative evidence. You have, as a human being, more than just the sense of sight. You have the sense of hearing. You have the sense of smelling, tasting. Do that in a case where the plaintiff had brain damage and he was a baker. He couldn't smell anymore, so he lost his vocation. He couldn't distinguish between peppermint and cinnamon and chocolate. So you can purvey to all of the senses with demonstrative evidence. Particularly, there's more than just telling a jury, showing a jury what it is.
As strange as it may seem, sometimes cases may be lost by a competent or even brilliant lawyer when the jury decides for an inept lawyer out of sympathy.
Yes, I don't remember any specific case, but I know it's a thing that a lot of us are scared to death about. And some insurance companies deliberately go out and get the young fellow who ought to be in knickers, who has a youthful haircut, a youthful smile, and a lot of gee whiz expressions. And if he doesn't get too corny, if he gets too corny, of course, then you can find him out and point it out to the jury. Be awfully, awfully careful, because if you're trying to show that the fellow is inept, that he's too young, he's too inexperienced, that could backfire, and you've got to be awfully careful how you do it. But I've seen insurance companies take an inexperienced lawyer who is just but bad out and send him in the courtroom and have him stumble around and make a lot of mistakes, scare the hell out of me that the jury is going to feel sorry for him, or they're going to substitute their crutch for his lack of having one that he needed, at least forensically.
How much time should a lawyer save for rebuttal?
They asked Abraham Lincoln, how tall should a man be? Long enough so that his feet will reach the floor. How much time do you need? Enough time to do a job. Sometimes you don't need a tremendous amount. Sometimes you do need an awful lot. But always reserve a little for rebuttal. Don't reserve more for rebuttal than you have in the opening, because I believe that you should set the whole tone of the argument in the opening, and then the other side spends his time rebutting or trying to catch up to you and doesn't make his points initially. So use as much time as you need to get your whole case out in the opening.
The key mistake to avoid in summation and in rebuttal is...
Don't be boring. Gee, do something. I told you the story the other day about the guy when the other lawyer was arguing and was making some points, that he was take a pencil and a knife and sharpen that pencil and try and get the jury to pay attention to him. He couldn't get the jury to pay attention to him unless the other guy was boring. Don't be boring. Don't be irrelevant. Don't talk down to the jury. Gee, don't ever talk down to the jury. Be of one with the jurors. And that's true, and you've got to have the feeling that this is the one thing that makes America great, the jury. And what a wonderful thing to give up their time to come and sit on the jury and to decide the dispute of a neighbor. Everybody would like to live in the United States all over the world. What reason? Well, because life, liberty, and the pursuit of happiness, because of our Constitution. But the Constitution, again, I say, would stay in the glass cage if it isn't for the lawyer and the judge to bring it out and make it alive, and you people, you jurors, really to make it come alive. The jury is such an important thing, such an important thing. I have a love affair with jurors and juries. I've had some bums, I've had some bad ones, but as I said the other day, to err is human, and you always get some bad things, and you always get some doctors that do get in trouble because errancy is a human failing. Errancy on a jury. Some of them do bring some prejudices into the jury room. We do have rules. We do have voir dire. We have rules to weed some of them out. But in this life, I guess you can't get perfection in anything or everything. But we do the best we can. We do one hell of a good job on trial.
Some of the most effective closing words ever used are...
Fine for the plaintiff. Tell them what the adequate award is. I don't know. Every one is a different one. Some of the great closing arguments were never given. A lot of it is spontaneous. If you love your case and you've really gone into your case and read about your case and talked about your case, and you want to do a job for your client, and if you don't, you shouldn't be in there, a lot of that, of course, is spontaneous. And as I say, Captain Kidd, what he told me, 50 years ago in law school, it all comes back, it pours back. That's why it's such a wonderful thing standing up there in front of the jury. One of the jurors the other day came up to me after I'd argued a case, and they said, "We loved your closing argument, but you told that story about the little kid with the chewing gum. And you were smiling all the time that you were telling. What were you thinking about?" And I said, "You know what I was thinking about? I was thinking about what a wonderful thing it was to have been in Captain Kidd's classroom and sitting there and him telling us those wonderful stories. And I haven't thought about it since then, until I was with you people the other day. I couldn't help but smile. What the hell happened to this wonderful thing that's a human mind that came out of there someplace?" I'm telling you good people, I guess it was because I liked you and I gave you one of those secret things that was tucked way away in there, and that's the reason I was smiling.
No matter how brilliant his openings or closings, no matter how well a lawyer prepares for a case, no lawyer is going to win them all.
Well, I guess every case that I've lost, I was too confident of and had to go out behind the courthouse and cry with or without my client. Gee, you know you're going to win a case. You should win a case, but strange things happen in trial. Now, that's one thing that makes the game or the law so interesting to the lawyer. It doesn't make it so interesting to the layman. It keeps him in suspense and in pins and needles till the jury comes back. But why they come up with this, some of their reasons, I don't know.
Sometimes during a summation, when everything has gone just right, a lawyer can have the experience of feeling what Dr. Belli calls when the ducks fly.
Oh, I think every lawyer has an expression the wonderful part of a closing. You can feel it. The electricity is in the air. You have rapport with the jury. You can feel it with them, with you, and you're with them. They're almost to the point of applaud. I never have had them applaud, but then I've never brought a bass viol in for a final argument, which sometimes before I hang up my running shoes, I would like, when I come to the final argument and the judge says, Mr. Belli, you may proceed, I'd like to stand up, and as I get really swinging into the final argument and get into the peroration, I'd like the door to open and the fellow would come in with the bass viol and play a few strains to finish the last part. I'm kidding, of course, but it's like that. You know when you're coming to the great part of the trial, the peroration, whatever, and you save something for that. You save something that they won't forget. All man does is live. When you're suing for the bum that lost his leg, I'm a hobo. I lost my leg. I like to walk around on two legs. My leg, my life, I love it. I'm a bum. Maxie in Southern Pacific, and the federal judge says all man does is live, in his opinion. And I think you come upon great things in the law. The language is beautiful sometimes when read or remembered or paraphrased by the lawyer. And at those moments that you really have a feeling with that jury. Again, it's putting the sobriquet, it's putting the name to a case.